In essence, when we invite people to come and act, we want to create the appropriate capacity for the courts to deal with the work that comes to the courts. I have yet to see of a judgment, until I took over, of course, coming from that court that was upheld by the SCA. I hope that makes my point, because we all exclaimed and discussed every time we had to deal with a judgment, an appeal from that high court. And there was a reason. It was a court that was run mostly by one permanent judge and acting judges. Now, that sends a very negative message to the litigating public in terms of confidence in the justice system. The work that comes to the two high courts, those of you who've acted there will know it's unlike in any other division. The first thing that frightens the hell out of them is the volume. And the other divisions don't have that amount of heavy work that we have in Johannesburg and Pretoria. DJ Pilidwaba will tell you that 5 weeks before, if he hasn't seen the roster, about 7 weeks before, he'll say to me, who are my judges doing the third court in the first week? Now, the third court, that's the court of the special motions. You have 2 in a week. But don't think that's nothing, because once you are hit with a volume of papers to read, or even the complexity of the issues at stake, then you understand. Then there's the normal opposed motion court, where in Pretoria you get nothing less than 14 at any given time. Those opposed motions are not easy matters. We try to ensure that the people who come are people, firstly, who want to consider a permanent appointment, because we want to build a pool wherein we will draw when we need people. Now, we look at those things to say, in what specialty areas are people involved in? But we don't just put you to do that work only, because a judge must be able to handle anything that's thrown at them. What then follows is, what judgments can we expect from the people who we are calling to act? I was surprised at the speed with which Judge Bakwa delivered his judgment this morning, having had argument early in the week. Now, 2 things need to be mentioned about the Bakwa matter. And I use an example, it may be a bad example, the Pistorius matter. Judge Masipa was chosen to do that matter in October of the previous year. But the media don't know how to read roles. They didn't know. They thought she was appointed 2 weeks before the trial. Now, when they heard that, they wanted to challenge me, because they expected a certain gender and a certain race to hear that matter. We want to have a justice system that South African society, in all its facets, can relate to. So if we are going to perpetuate stereotypes, we're not going to go anywhere. We emphasize that it is important for people who want to be appointed permanently to come and act. In fact, I have had occasion of people who've acted for 2 weeks, they've seen an advert and they say they are going to apply. And I've been honest enough to say I'm not going to shortlist you. I'm not going to shortlist you for the simple reason that there are people who may have made a mistake when they chose to come and work in the Gauteng division and the Gauteng local division. I will not support anyone who wants to be appointed permanently who has not acted in the division. Because we think the exposure to the work, the volume, the complexity, and the lack of quality time during term, time to have a lot more time to sit and relax like the guys in the SCA. To consider their judgments from all angles. I have an agent court that sits 2 judges per week. Take your unopposed motion role in Pretoria and transform it into an agent court, or in an opposed motion that's become agent. Then you'll understand what I'm talking about. So if you have not acted in the agent court of Gauteng, you don't know what's going to hit you when you go into that court. It used to be 1 judge, I know, in Johannesburg, and in the unopposed motion roles, it used to be fewer judges for a lot more matters. We've tried to introduce reading days and to expand the judicial capacity that deals with that. But you'll be surprised to know that the unopposed court may appear a simple court. It's not a simple court. It's not an easy court. There are guys from the bar who've come and I've put in that court. And I've had feedback, because that feedback is important to me, to say, whoa, the person was out of his or her depth. So I do not easily put acting judges in the unopposed court and in the agent court. Let me just deal with the elephant in the room. When I took over as JP, I appointed a number of magistrates to act. And I'm told the going joke around the Johannesburg bar was that the South Gauteng High Court has become the South Gauteng Magistrates Court. We have magistrates, we have you guys from the bar, and we have attorneys, some now and then from the academia, who want to come and act. Advocates, in the nature of their work, do a lot of drafting and do a lot of court appearances. So that goes a long way into informing us to say the courtroom environment is not far away from people from the bar. Compared to attorneys, very few do their own appearances in the High Court. They brief, they sit next to counsel. I will put a silk, even if he's a first-time acting person, in the opposed motion, because I know that's what he deals with. And in terms of writing judgments, that's not much of a problem, in the sense that you are used to drafting. So that's why you'll see sometimes I'll put magistrates and now and then attorneys in the normal appeals, because we need to see how you confront the work, what you produce as drafts before it goes out there. When I took over, I found what is called, or what was called, permanent actings. You know what I'm talking about. Now, these are people who were beyond appointment age, but they were acting from year to year. And the issue was there's hunger and there's a need to create a pool. So these people are closing up those acting opportunities for people who are younger and who are prepared to come and give of their time to act. That's why you're no longer seeing them. In terms of how we select acting appointments, I had a long chat with former JP Ngwebe. White males, I was told, is an endangered species. And I said, I don't agree. And I want to repeat that here. I don't agree. There are people who sit here who are very pale and male, who have come to act. But there, we are strict. We ideally would want to appoint from silks. That constraint only applies to white males. But as I say, we do, Judge Ledwaba is here, appoint from beyond silk ranks, from the white males. Now and then we've appointed outside the silk ranks. Part of the reason is there's a complaint from silks who say, I will not come and act because I don't want to appear before someone who's my junior at the bar. Those are things that come to us. I don't think we should countenance that, but it happens. In terms of gender, white females ideally would look at the silk ranks, but we know that that's a small pool. So we do appoint largely outside the silk ranks for white females. In terms of what is called PDIs, I don't know where this term comes from. That constraint does not apply, because if we are going to perpetuate previous stereotypes, and if we are not serious about transformation and insist on silks all round, the bench we will have is not the ideal bench. We now have senior judges who come from attorney ranks. In my division, some of them sitting in the SCA. Unless you ask, you will not know that this person was an attorney. So I'm just saying the stereotype and the myth that says the best judges come from silk ranks is not correct. And we are alive to it. We are mindful of the concern sometimes expressed by silks that I approach to say my practice will suffer. It's an act of insolvency to take an acting appointment. The problem with that is silks struggle to give me in the main more than 2 weeks. They actually wanted to give me a week at a time. And I said, nah, I'm not going to go for that. And when I say silks, I'm talking about black and white. Yeah. Now, 2 weeks is not enough to equip you as a judge. It's not enough. If you go to the JSC and you see the approach I adopt when people apply for permanent appointment in the Gauteng division, if you've done less than normally 2 terms, 2 terms is roughly 20 weeks. If you've done less than that, I will be hesitant to shortlist you in the first place. On top of that, what we do, you can give me your 2 weeks a year, but if you say now I want to become permanent, I say, well, I want a term. I want a term, week 1 to the last week. Because that's what will tell you whether you're making the right decision or not. You will carry a normal judge's load per term. If you haven't done that, it's going to be difficult to appoint you. I was shocked when some very well-meaning senior members of the bar came to act, and I would chase and chase and chase for judgments that have not come. And if you check how long the people acted for 2 weeks. Silks usually want to dictate to me to say, I don't want to sit in normal appeals. Put me in the opposed motion or put me in the special motion or in the urgent court, right? Unless you put me there, I'm not going to come. I've not appointed those people because we as the permanent judges are the custodians of the jurisprudence making process of the courts. I put silks now and then in the opposed motion, in the special motion courts, but not to have a situation that all the judgments in those key areas come from acting appointments. It doesn't send a good message. So when I approach you, you say to me, you'll only come for a week. I'm not going to call you again unless you consider. I've relented. I know that in the past, the insistence was if you give less than 5 weeks, you're not going to come. I've relented and gone to 2 weeks, right? I said, but as long as if you come for 2 weeks, maybe you can give me 4 weeks in a year. 2 weeks here, 2 weeks there. But once you've decided that you want to become permanent, I want more. The issue of judges who reserve judgments and the insistent request from parties for those judgments. The perception is that if you pressurize the judge to give you a reserved judgment, he'll find against you. It's a perception. That's all there is to it. It's a perception. It's not real. Unless you come and tell me that it's happened, right? Because in the main, in Johannesburg and Pretoria, because of the workloads we carry, you find that most reserve judgments are within the 3 to 6 month range. And they change every time that cycle changes, because that's when people get time during the long recesses to write those judgments. But then we have a select few who reserve longer. I've specifically tracked those who've written to me to say, I want that judgment, and I've checked. This is a perception that they'll find against you. So I want to encourage the profession to write to me, to ask for those judgments. Because this thing of sitting back and say it will come when it comes is not helpful. It's giving us a bad name. I'm happy that when we changed the motion court practice in Johannesburg, there were silks who were acting at the time. I mean, in Joburg, you could enroll your matter on a Thursday and you could be heard the next week. Now, I openly said to my judges, that's less than quality justice, because the judges in Pretoria have a very unfair advantage over them. They get their opposed motion files at least 2.5 weeks before they hear the matters. So when they come to hear the matters, they're ready, they've read them. In Joburg, you'd be surprised if the judges were ready. I mean, I was an acting judge there, I worked there. If you're in that court, you get your opposed files on the Tuesday morning when you're busy with your unopposed, and you're supposed to start with those files the next day. You can't be prepared. That's why we've changed it. I know it's hit some people hard in the pocket, but I think you're getting better justice now because the judges are ready. They are prepared. I want to encourage interaction with my office, with your leadership, but I want to also say the reluctance by advocates to take part in training initiatives like this, unless they are run by their own. The appetite from advocates to go to aspirant judges training programs by SAJE is not there, unless you have advocates and unless you have judges. Judges permanently, who are permanent, go to training seminars, training workshops. So you find that you benefit a lot by just sitting and hearing how people who are experienced as Justice Brandt are when they share with you your perspective, their perspectives of, he spoke about judgment writing, but I'm just saying, please reconsider the general reluctance that I see when SAJE issues out invites for aspirant judges training. It's mostly the attorneys who respond. The people from the bar do not respond. I do not know what the reason is, but it goes a long way. Let me stop there and sort of take questions and comments. Thank you very much.